honorable guests, it is a great pleasure to address this conference, which is the fifth, as Nicola noted, that has been organized by the Procedural Law Unit, which is a sub-unit of the School of Law of the University of Nicosia. I think we were very lucky to have Nicolas join us in the school. He's extremely active, bringing together academics from across the globe to Cyprus for this annual event, which has allowed, in all its iterations, very interesting and stimulating discussions on the rule of law and the workings of civil justice. The topic of this conference is, of course, of extreme importance, and there is no real need to underscore or analyze the importance or the significance of judicial independence for the rule of law. Let me, however, point out a few things as stimulus for further discussion that might be of interest to Cyprus nowadays. The first thing has to do with how judges are appointed, promoted, transferred, and of course undergo disciplinary proceedings. There had been a great discussion about the composition of the judicial body that would be responsible for these acts. Eventually, it was agreed that representation from the bar and from the Attorney General's office would participate in this body, but without a right to vote and without participation in the disciplinary proceedings or the transfer decisions. Now, I think there is an issue to discuss there on whether participation without the right to vote and without participating in specific decisions actually increases public trust in the whole procedure or not. Of course, academics, we also like to speak of our independence, and we would not have liked, for instance, in the ranking procedures, whereas an academic will be promoted for someone other than experienced academics to participate. So I see the logic on why judges might be reluctant in some ways in anyone other than Supreme Court judges to participate in these proceedings. On the other hand, because under the ENQA framework, to use also this example where academics are regularly and the universities and programs are regularly monitored by the national accreditation authorities, the framework for quality assurance explicitly provides that in addition to experienced academics, you always have, if you are a professional program like law, a representative from the bar participating in the committee, and also a representative from the students. This is actually true also for our disciplinary bodies. It's actually true for many things. So my point is that a wider composition is of extreme importance because Supreme Court judges are often not there to see what is happening in a district court. So this is why you need the representative from the bar that has the actual experience of members of the bar going before the judge. So this has also been discussed by the Venice Committee and by other organizations, but I think the reluctance to have a full participation in regards to these issues would not, in my view, be consistent with modern approaches on how this issue should be approached. And I think I wouldn't consider the argument of judicial independence to go that far, that only judges should decide these issues on judges. Of course, the majority should be judges. There is no discussion about that. But if you have a 10 body composition and the 8 are judges, and you have 2 who are not judges, I don't see why those 2 should be without a right to vote. Obviously, they would not be the defining factor if the judges are of one voice. So I think the extreme reluctance that the judiciary showed in the discussion of this issue during the recent amendment was problematic. I'm raising it because, of course, the conference has wider comparative perspectives, but I think in my address I prefer to focus on some points from Cyprus so as to allow you to consider them during your comparative discussions that will follow. The second, of course, is to what extent, when we refer to judicial independence has to do with independence of individual judges within the justice system. Now, this has proven to be of late a rather controversial issue within the Cypriot justice system. We have had one very high-profile case that has attracted a lot of media attention as well, of one judge who has been terminated, and the case is still pending before the Supreme Constitutional Court, acting as a review body. Right now, the decision is pending, so I will not delve too much in the details, but I want to delve not in the individual specific characteristics of this case, but in the wider theme. And the wider theme is, if we acknowledge that there is a review body, in the case of Cyprus, say the Supreme Court, to what extent can this review body get in the individual judgment exercised by judges, which does not have to do with delays or with issues of complaints for behavior and similar issues, but which has to do with the substance of the judgment. Can you review or monitor the substance of the judgment not as part of an appeal, but as part of disciplinary proceedings without this case having been reviewed in appeal? Because when we discuss judicial independence, we often focus on judicial independence from the executive and the legislative and so on, but judicial independence within the judiciary is also a major point, that because the judiciary is a hierarchical system, we should not neglect in our discussions. There is also another pending case now that raises in disciplinary proceedings of judges some of these issues, but this is not publicized, so let me not get there. The third point, and I will be brief, has to do with the real extent of when do we consider that the legislative interferes with judicial independence. And I will tell you a case, a recent case of the Cyprus Supreme Court that actually troubles me a lot, and it would be interesting to share perspectives from our international colleagues. The House of Representatives had enacted a general law that has to do with obligation of all public officials to disclose their income and their property, which has to do with the principle of transparency, so that there can be trust of the public that public officials, have not gotten richer during their public service. This law is a general one, so it included every public official. And there was a decision to include members of the Supreme Court, but the House of Representatives, in an act of deference to the Supreme Court, stated, we will not include the judiciary as part of the general law, but we shall suggest to the judiciary to enact their own regulations to handle this issue. So the Supreme Court examined this law, and they decided that the suggestion that they should handle this issue with their own regulations amounted to an unlawful interference of the House of Representatives of the legislative body with their judicial independence that ran towards separation of powers. So this is a unanimous decision of the Supreme Court. Now, in my perspective, the House of Representatives had the power under a general law to legislate the judges as well. This did not have to do with how they issue decisions. It had to do with a general obligation that has to do with transparency. Similarly, as you do it for the President of the Republic, the ministers, the MPs, I don't see how judicial independence would be threatened, even if they decided to include them in the general legislation. But the mere suggestion that the judges themselves should undertake regulations, how does it violate, under any, in my view, reasonable perspective, judicial independence and separation of powers? I think that it is important for the justice system itself to also acknowledge that judicial independence is, of course, should be a right, but at the same time it creates obligations. I mean, it has obligations towards the public, towards public trust, because if we consider that judicial independence becomes unfettered and the judges are beyond reasonable reviews that the executive, the legislative, anyone else would be under, then you understand the trust of the public would not be there. And I think judicial independence has to be consistent with public trust, not a way to decide that the judges would be beyond any reasonable, I repeat, reasonable review. So in my view, and of course, I'm always open to hear other perspectives. That's why I said I'm raising issues. I'm not ending discussion in any way. But I think this judgment went too far in considering the issue of judicial independence. So just some thoughts, dear Nicolas, for your conference. I have seen many faces from other countries. I know very knowledgeable people, and congratulations for bringing them here. I'm sure this will prove to be a very fruitful discussion. Thank you very much.